Lawyers, what complex case hinged on one tiny overlooked detail? Case 14 Mendota Insurance Company versus Ware, 2005. In this case, an insurance company and a policyholder went to court over a typo on a single sheet of paper. The dispute involved an automobile insurance policy. On the declarations page, which is the summary sheet that lists coverage limits, there was a clerical error. The policy listed coverage for property damage and bodily injury. However, next to the property damage section, the document accidentally used the letter A instead of the letter B. The insured party, Ware, seized on this mistake. Their lawyers argued that this typo created an ambiguity in the contract. No. Ware's team argued that because of this confusion, the stated limits on coverage shouldn't apply, and they should be entitled to unlimited coverage for their bodily injury claim. The Missouri Court of Appeals had to decide if a scrivener's error, a fancy term for a clerical mistake, was enough to void the policy limits. They applied the reasonable reader standard. They asked, would a normal person reading this document understand what it meant despite the typo? The court decided that when reading the policy as a whole, it was obvious that A was just a mistake and didn't change the actual meaning of the coverage. Result, the court ruled that the typo was an obvious mistake and did not change the coverage limits.